Oh, it does on the display. That's it, yeah. Yeah, that's it so far, yeah. No, but I was told there was another. No, no, I don't. Let me, I'll walk over there next.
I saw that. I couldn't stop laughing. I'm like, that has to be.
It was a vibe.
Yeah. He was not. He was not there. It also probably was.
Good afternoon, everyone. We are so glad that you're here today. Thank you for coming out. In just a moment, our State Attorney Monique Worrell is going to share with you some very important information and update on our non-arrest policy. After, we are going to be taking some questions and giving you some answers. However, we would just ask that all the questions remain on topic. So I'd like to, without further ado, introduce our State Attorney, Monique Worrell.
Thank you. Please hold your applause. Good afternoon, everyone. I thank you all for joining me on what is obviously very much anticipated address on the current situation dealing with the backlog of non-arrest cases here in the Ninth Judicial Circuit. I want to start by letting you all know that about 9:30 this morning I received a call from statewide prosecutor Nick Cox, and we have arranged a meeting for tomorrow where we will discuss how we can implement the assistance that has been offered by the Attorney General. I look forward to meeting with him to discuss how we'll be working together to clear the more than 13,000 non-arrest cases that have backlogged in our circuit. I also look forward to sitting down with local law enforcement to discuss additional collaboration in this policy, and I want you all to know that those discussions have been in the works ever since the release of this non-arrest policy a few weeks ago. As I said before, collaboration is critical to ensure the public safety of our community and to removing violent offenders from the streets. Public safety should always take precedence above politics. And while we know that this circuit receives more scrutiny and different levels of scrutiny because of politics, we have an obligation to work together to solve the problems of this community. So I look forward to collaboration with all relevant stakeholders to put public safety above politics. And putting public safety above politics means being honest about the facts that this problem has been allowed to grow and fester for decades. And what I am doing right now, here today, and with the implementation of this policy, is putting an end to temporary solutions that haven't fixed the problem. And I believe that by working together, we can permanently fix this backlog of non-arrest cases. So, unfortunately, what the Attorney General has offered is another temporary fix to the situation. The statewide prosecutor's office has a long history of providing support to local jurisdictions and providing additional prosecutors, and of course having them come to our office is welcomed. We can certainly utilize the help so that we can work as quickly as possible to get through the backlog of cases, and after we've done so, I will continue to advocate for additional permanent resources, because once that temporary support is no longer here, we can expect that backlog to creep up again. As I stated in my letter to the Attorney General, this reality has far more to do with flat funding while our population has grown exponentially. And an increase in population necessarily results in an increase of cases coming through our system. But the resources to review these cases just haven't kept pace despite our repeated requests for additional funding. I think I said when I rolled out this policy that year after year we go to Tallahassee to lobby for additional funding, additional spaces for prosecutors in our office, and year after year those requests are denied. We need a holistic approach, which is why in my letter to the Attorney General, I requested 13 additional prosecutors and support staff to process this backlog and to make sure that we don't just create another backlog. It's vitally important that additional support is provided for the long term, because when those resources aren't present for even a short period of time, the case backlog can quickly escalate. During my first administration, or what we've affectionately referred to as 1.0, I put in place staff to work solely on reviewing those non-arrest cases. And under the interim administration with the appointed state attorney, the staff was either released or reassigned. And at the end of 2024, there were 12,118 non-arrest cases that had come in. So I just want to reiterate for all of those who have heard differently and for those who are saying differently, this is not a Monique Worrell problem. This, in fact, is a problem that dates back to at least 2013, where, as WFTV reported at that time, Jeff Ashton was discussing non-arrest cases that he inherited when he took office. And his solution to many of those cases was to drop those cases. And we have worked diligently to ensure that we don't have to drop cases because we don't have the manpower, but rather that we get the manpower that's needed to adequately service the people of the Ninth Judicial Circuit. I know it's a good political talking point to try to make this about me, and some continue to try to do so, but this community deserves better than that. They deserve more than politics. They deserve results. And that's exactly what I will continue to advocate for. Now, I have some numbers that I want to review with you, and I'm also going to have one of my investigators, my Deputy Chief Investigator, Dave Amon, come up and talk to you about some of the non-arrest cases that we've received so that you can have some more concrete examples. It's something that I didn't do before, but I want you to receive these concrete examples so that you can have an idea of, when I say non-arrest cases, what I'm talking about, because it's very important for the public to understand that. All right, so on the screen behind me, you'll see, and I'm highlighting the last several administrations so that you can see what the numbers were under each administration so that you can have an idea of how this is relative and also how it's not simply isolated to my administration. So in 2012, that was the last year of Lawson Lamar's administration. He received 13,459 non-arrest cases. I'll move to the side so that I'm not blocking your shot. All right, and in 2016, under the last year of Jeff Ashton's administration, there were 13,110 non-arrest cases. In 2020, under the last year of Ms. Ayala's administration, there were 12,660 non-arrest cases. But what's important to note with that is that it was also the COVID year, so all of the numbers of cases filed that year were down. In 2022, the last full year of my first administration, the number was 13,512 non-arrest cases. And in 2024, the last year of the appointed state attorney's administration, it was 13,459. So you'll see that the number of non-arrest cases that's received is relatively the same, no matter who's sitting in the seat. And that's really important, again, because when people try to make this a Monique issue, the numbers say something different. So I'm going to preempt your question, which may be, well, it wasn't a problem for any of these other state attorneys. Why is it a problem for you? Well, the answer is it was a problem for each of these state attorneys, and each state attorney has employed different tactics that they use to try to address the problem. All of those policies that they implemented were only temporary fixes to the problem. What I'm advocating now is for a permanent fix to this problem that several other administrations have tried to find but have not yet been able to do so. I want to talk to you a little bit about where the non-arrest cases come from, the majority of non-arrest cases come from. Orange County Sheriff's Office and the Orlando Police Department are our two major law enforcement agencies in this community. And in 2023, from Orlando Police Department, we received 1,475 non-arrest cases, in comparison to the Orange County Sheriff's Office, from which we received 4,915 non-arrest cases. In 2024, the number from Orlando Police Department was 1,712, in comparison to the 5,789 received from the Orange County Sheriff's Office. In 2025, and we're just in April, we received 488 from Orlando Police Department and 1,614 from the Sheriff's Office. So as you can see, the majority of non-arrest cases that we receive come from the Orange County Sheriff's Office. And I'll tell you that that is about policy. So if you look at the Orange County Sheriff's Office policies with when to send cases to the state attorney's office, you will see that in that policy, under number 4, file charges with the state attorney's office, specifically in C, it says that if the incident involves a non-view misdemeanor and the charge is not a warrantless exception, the deputy shall means you must, file the case with the state attorney's office, not arrest or try to obtain an arrest warrant. So in the Orange County Sheriff's Policy Manual, they direct their deputies to file cases instead of seeking an arrest warrant or making an arrest. So this in and of itself can account for why you see that there's a dramatic difference between the number of cases that we receive for the Sheriff's Office as opposed to the number of cases that we receive from the Orlando Police Department. Now, similarly, if we look over at the policy that comes out of the Orlando Police Department, one of the things that's been addressed here today is that the judges are not signing for misdemeanor warrants. Well, Orlando Police Department has put that in their policy. It says that the Orange County judges will not sign a misdemeanor-only arrest warrant unless there is evidence that the defendant is unlikely to appear for a summons. If submitting a misdemeanor-only warrant, officers shall fully document in the warrant affidavit all evidence demonstrating a defendant is unlikely to appear on a summons. The evidence may include all efforts to locate the defendant, facts showing the defendant's a flight risk, a record of failing to appear for court, and any transient or unknown resident status. Here, the Orlando Police Department has outlined in their policy what you need to do in order to get a valid arrest warrant. And this is why we're seeing a lower number from the Orlando Police Department than we're seeing from the Orange County Sheriff's Office. There's policies and procedures that have to be followed, and these policies come from the law. So when they're saying that we can't get warrants, well, they can get warrants, but they have to provide the information that is required by the statute in order to receive those warrants. Since the start of our policy on April 1st, of the 225 cases that we received from the Orange County Sheriff's Office, of the 255 total non-arrest cases that we received, we returned 225 of those to the Orange County Sheriff's Office for non-compliance with the policy. Out of the 225 non-arrest cases returned for non-compliance, 85 of those cases were domestic violence cases. Now, I want to take a moment to talk about the importance of domestic violence as it relates to this whole non-arrest conversation. When a victim reaches out to law enforcement because they've been involved in a domestic violence situation, this is a cry for help. They are reaching out to law enforcement because they have been harmed in some way, and they are asking for help. When that case is sent over to the state attorney's office to sit on a shelf with 13,000 other cases, that's not giving them help. And you can say, well, why don't you do something about it? Why do you not let it sit on a case with 13,000 other cases? And I'm telling you, the reason we don't do that is because we don't have the resources. We want to help the victims and survivors in our community to get the help that they deserve. That when they call on law enforcement to get help when they are a victim of domestic violence, that their abuser will either be arrested or that a warrant will be put out for their arrest, and that they won't let their case languish on a shelf with thousands of other cases with an already underfunded and overburdened state attorney's office, that we will get them the immediate help that they need to keep them safe. To that end, I want you to know that, the next slide. In 2021, we received 3,226 domestic violence non-arrest misdemeanors. And of those, we filed on 308. The reason is because by the time we're able to process through that cases, you have people who aren't around anymore. You have evidence in a case that's been diminished. And we can't bring justice to those victims who have reached out to our office for help. That number could increase exponentially if arrests were made on the scene, if the proper evidence was gathered at the time. And our domestic violence unit has met repeatedly with law enforcement in an attempt to partner to build the best and strongest domestic violence cases from their inception, telling them what's the evidence that they need to gather so that we can successfully prosecute this case. My chief of domestic violence has done trainings with law enforcement and is continuing to do training specifically this year with the theme of strangulation and how law enforcement can recognize strangulation, domestic battery when they go to a scene so that we can help save victims. So we take this very seriously, and anything that you're hearing that tells you otherwise is just simply false. In 2021, we filed on 9% of these domestic violence cases, and I want you to know that that's coming from 2010, where only 3.6% of those cases were filed on. So again, if someone's telling you that this is a Monique Worrell issue, the numbers don't lie. People lie. Numbers do not. So we are filing on more than 3 times more cases than previous administrations have filed on. But yet still, this number from 3,226, where we only were able to file on 308, is not good for our community. That's not keeping our community safe. So I'm going to have Dave come up. He's going to talk to you a little bit from a law enforcement perspective. It's important for you to know that I have law enforcement officers right here in this building. But I don't have 2,000 like the agencies have. I have 13. And those 13 law enforcement officers help us with serving subpoenas so that we can get our witnesses to come to court and testify so that we can make our best efforts to bring justice to the victims of the Ninth Judicial Circuit. But he's going to talk to you because he's been diving into some of the non-arrest cases that we receive and why it's so important that we work collaboratively with law enforcement to reduce the number of cases that we have to lay eyes on when they really can make determinations on their own. So Dave, would you come up and talk to that?
Good afternoon again. As you see, I'm going to kind of change my hat. I'm the de facto PIO here, and we're hoping to get a full-time person on board. But I'm also one of the investigators here. As State Attorney Worrell said, we have 13 sworn police officer investigators here, 2 of which are standing on this stage, and we're tasked with covering our entire circuit, which is Orange and Osceola County. So what we had done when we discovered this backlog, we tried to step in, and under both administrations recently, we've assigned 1 full-time investigator to take a look into those 13,000 cases. Now, you may ask what type of cases. I've had that question from you folks are in the 13,000. Well, if I had a crystal ball, I could look into them. But what I can tell you today is some of the cases that we have seen. Our office takes domestic violence very seriously. Although it is a misdemeanor, we can see that we cannot tolerate violence, and many times domestic violence can lead to more serious cases, such as homicide. We see that recently. So we've kind of done a focus on domestic violence, and one of the things we've seen is we are really excited about working with our law enforcement partners because, as we've stated from the podium before, a law enforcement officer needs what is called probable cause to make an arrest or go and obtain an arrest warrant. And usually when they make an arrest, that's when that case comes to us. Now, once it's passed to us, we have a much, much higher burden of proof, and that's called proof beyond a reasonable doubt, which is something that we would have to show in order to obtain a conviction. Well, what we're seeing in a few of these cases, and I have some examples that I'll read to you, are that the law enforcement officers have been sending cases over here where they haven't even jumped the hurdle of probable cause calls yet. As a matter of fact, some of the cases that we've seen statements written in affidavits such as unable to substantiate probable cause. Well, if you send us a case that you're unable to substantiate probable cause, the likelihood of us being able to jump that bigger hurdle and say we can prove that case beyond a reasonable doubt is really, really going to be difficult. So suspect was not arrested due to lack of evidence available to establish probable cause. Throughout the investigation, probable cause could not be established. So those cases are going to prove problematic. Again, I said I don't have a crystal ball to see what the 13,000 are, but from our past review, we've noticed that there is a sizable amount of these cases where if we could just ask law enforcement, instead of sending those cases to us where they haven't met their burden of probable cause, that they work with their detectives and maybe, try to bolster their probable cause. We do have on-call prosecutors, multiple prosecutors we send out every week that are on call to where local law enforcement can give them a ring and they can talk about that. We even have specifically a domestic violence prosecutor on call all the time. So we would ask that before you send them to our office and they sit in a stack and we already believe that they have no probable cause, that either you work a little harder to get probable cause, or sometimes there's just not going to be probable cause, and there's nothing magically that the state attorney's going to be able to do to take that no probable cause. There's nothing we're going to be able to do to make probable cause. So what an effort, and I'm a career law enforcement officer, worked all around the circuit here, so I know a lot of these folks. What we're trying to do is say, hey, could we just, if you don't have probable cause, could we not send them over here if you don't have probable cause? Because all that does is make that cases that we have to go to and sometimes say, yeah, you don't have probable cause. So we're obviously not going to file on that. So we want to kind of, instead of a floodgate, we want to see if we can work with them to narrow our focus and send only the cases that have probable cause. And if you don't, give us a call. We'll see if we can help you get probable cause. Contact your legal advisor. So as far as our investigations unit, that's what we're going to be working with law enforcement to see if we can just narrow that. The fewer cases we get, the more attention we can give to those cases. Thank you, Ms. State Attorney.
The probable cause discussion is really important. I was looking through social media after my last press conference, and I saw that someone commented that I want law enforcement to do the state attorney's job. And what that showed me was that people don't really understand the separation between law enforcement and the state attorney and what our different roles are. So it's really important to understand that the role of law enforcement is to make sure that there's probable cause. Probable cause means that it is probable that a crime was committed, one, and that the person who they are making the complaint against probably committed the crime, right? It's very basic. If law enforcement can't establish that, there's no way that we are going to be able to establish that. And the reason is because they're on the scene. They're interviewing the witnesses. They're talking to the victim. If they can't establish probable cause at the scene of the event, there's nothing that we are going to be able to do to build probable cause once the case gets here. So it's really important for the public to understand what the role is of the state attorney and what the role is of law enforcement and how those roles are different, but how one builds upon the other. So when we get the case, our job is to now take law enforcement's probable cause and take it to beyond a reasonable doubt. And sometimes, through no fault of law enforcement, we can't make that happen. Sometimes we get probable cause and we can't turn probable cause into beyond a reasonable doubt because there's just too many things missing and there's a gap, right? And we work with them at that point to try to build it. But as Dave just explained to you, if the case comes in and it doesn't even have probable cause, there's nothing that we can do to make it beyond a reasonable doubt. There are a few things that I want to clarify, and there's some misconceptions that I'd like to address. If you remember from 1.0, I did a whole press conference about facts matter, because facts do matter. And when you are in a position such as mine as state attorney and some of the other elected and appointed officials who've made comments with regards to this policy, the truth is important. I want to clarify my policy because there's been some mischaracterization as this policy as being a blanket policy or inconsistent with policies that have been implemented by other state attorneys to deal with non-arrest in their own circuits. I think it's important for you to understand each state attorney is elected, for the most part, to deal with the matters that impact their circuit. So when I make a policy decision, I'm not looking for validation from any other state attorney for what works best in the Ninth Circuit, because the people of the Ninth Circuit, 414,000 of them, elected me to make decisions that are best for the Ninth Circuit. But out of an abundance of caution, what I do is I look around to other state attorneys to see if they're facing similar problems, if they've implemented similar policies, so that I can have a basis upon which to build for what works best for the Ninth Circuit. This was no exception. My executive director reached out to all of the other circuits and asked, do you have this problem? If so, how have you dealt with it? And to it, we received a policy that has now been widely circulated from the Fifth Circuit, where they also clearly had a non-arrest problem that caused them to develop a non-arrest case policy. As my policy states, non-arrest cases that will be accepted are homicides, sex crimes, human trafficking, child abuse, drug trafficking offenses, traffic homicides, animal cruelty, economic crime, wildlife commission cases, and civil citations. It's not a blanket policy because I just named for you, I don't know, probably 9 exceptions that allow us to review cases that are non-arrests. And in all other cases where we have said we won't accept them, my policy clearly has a provision where law enforcement can reach out to our on-call attorney. Now, we don't have just one on-call attorney. We have an on-call attorney for every single division in this office. We have an on-call attorney for domestic violence. We have an on-call attorney for homicide. We have an on-call attorney for sex crimes. So wherever there is a need for discussion, law enforcement can always reach out and we can have discussion, because our goal is not to regulate what law enforcement can and can't do. It is only to make sure that we are providing public safety measures for the people of the Ninth Judicial Circuit. My office will never refuse to prosecute a case where probable cause has been properly established. The only thing that this policy set out to do is so that law enforcement can help us build the strongest cases possible, so that when they come in the door, we're taking it down the road to beyond a reasonable doubt.
Did you get her purse and get the sugar coat?
We respond to 4 state attorney's office. One female unconscious breathing.
Okay, so we gotta make sure she's breathing.
10-9.
We'll get her airway.
Age, approximate age.
40.
Oh, for this.
Just make sure her airways. Get her pulse. Yeah, she's breathing. She's got
And
a
where in the
pulse.
building located?
Let's get her.
5th floor, training room.
You okay? Can you hear me, Shannon? Can you hear me? Can you hear me? Okay. We're gonna get someone to come help, Mike. Do you have any medication you need, or? It's Dave. Can, say again? Glucose? Go ahead, glucose tablets, let them know.
Okay.
We're getting them for you, okay? Just keep breathing, okay?
Is anybody going to need some
Can you hear me? You know who this is? You don't need to say you're sorry, okay? We got, you need
10-4.
We need to get her to sit up a little bit, just so we can get her. Roll on her side. I'm gonna need you to chew this one. And just put your head on my knee, okay?
You got it?
Yeah. All right, we got one. Coming. Monique's gonna put, here you go. There, 51.
Yep.
County to that St. Charles, can you let them know the medium is packed?
All right.
Will do.
Tony, if you bring them in through the bus,
I thought it was.
All right.
County Control will rock with it, check one, two.
Yeah, she's talking to us now.
SA3.
You guys are not filming, correct?
Therefore, she's conscious now. Remember,
Did we stop the Facebook Live?